Commissioner Carrier. Uh-oh.
Sorry.
Okay, Commissioner Carrion,
Yes.
Commissioner Hebner,
Yes.
Commissioner Jenkins,
Aye.
Commissioner Simpson.
Aye.
Commissioner Kubis.
Aye.
Okay, that completes that.
All right.
I hope that wasn't the beginning of the recording. Yeah.
Sorry.
We have people texting saying they're waiting and it says the meeting is will begin soon.
Yeah, I just got a message from Steve.
Have we,
The recording just started, so I think you have to let people in.
I have to let people in.
They're on now.
It's now recording.
okay, well, just to reiterate for the public, apologies for that glitch. You missed me saying, expect this to be bumpy. So that was the main thing that you missed. Other than that, the commission approved the minutes and they just approved a meeting schedule where the commission would cancel meetings retaining only the August 18, November 17, and December 15, with the understanding that the December meeting is contingent on necessity. Other than that, the executive director gave an informational report mostly about the process we're using. I am curious, can you check to see who's in the audience? Anyone other than David Carrillo? Oh, several people. Okay. Well, look at that. This was valuable. I didn't do all this work for nothing. Good, welcome. So that concludes that agenda item.
Okay, thank you. Next item is legislative program.
Yes, so the legislative program is going well. AB 1716 mention is would implement two of our recommendations on transfer of decedent property outside of probate. There are technical corrections that are going to be made presumably when the bill is next heard in committee, which is going to be the Senate Judiciary Committee. It's cleared the Assembly, it's in the Senate now, it's pending before the Senate Judiciary Committee. Once the technical amendments are actually made, I will present revised comment language for your approval that conforms to those changes. The AB 2293 and 2327 are authored by the Assembly Committee Environmental Safety and Toxic Materials Committee. Those are our proposals to recodify a significant part of the statutes governing toxic materials. Those bills cleared the Policy Committee, were heard in the Appropriations Committee, and the bill that has the conforming revisions was passed through without a hitch. The bill that would actually do the recodification was put on suspense. So that means that the committee will later hold a vote on it after they've just figured out how to address what they see as the fiscal consequences of the bill as a fraction of the overall state fiscal picture. The public records cleanup bill was passed last year. We had a separate bill for the conforming revisions, and we had a subordination clause in that bill so that the bill yielded to any other bill in the event of a conflict. And as a consequence, a number of our provisions got knocked out, and they have been reintroduced as part of the Legislative Council's annual maintenance of the codes bill. Thank you, Commissioner Jenkins. They were amended into the bill. It's a lot of language. So we proofed it. Megan, who I introduced earlier, did the heavy, close read of it, and then Barbara Gall. Barbara is retiring, by the way, so I don't think you'll see her again, probably. Barbara reviewed it too. And what we found was that some of our changes were omitted, and we identified those to the bill author, and we expect that they will be amended in later. And then we also saw some issues that were much less consequential, but worth noting. You know, there was a provision in the Penal Code 832.7 where the language used was different from ours, but the result is the same, and so we just want to leave it alone, and I wouldn't propose any change to comments. There's a provision that we would have amended, Education Code Section 32,090, that was not included in the bill. And when we checked, we concluded it was because it's sunsetting on 1/23. So there's no need to amend it if it's going to be repealed. So we're just keeping an eye on that to make sure that the sunset doesn't go sideways. And then there was a fairly lengthy list of sections where the Legislative Council drafter added technical corrections that we hadn't proposed. And that's commonplace when Legislative Council drafts a bill. One of the things they do is make technical corrections that they see. And so those are fine. We don't need to do anything about those unless we want to amend our comments to acknowledge them. And we have gone different ways on that in the past. I think typically more common is that we don't do that. It might lead to some confusion in the record, people trying to figure out where did this come from, but it's not our proposal. And so I think it's cleaner to keep that line bright and generally not comment on changes that Ledge Council proposed. And then the last note, there's Health and Safety Code Section 130,060. We had proposed a technical correction in addition to the cross-reference correction that was the heart of the proposal. Our technical correction was not included in the bill when the bill was amended to include our material. That's fine. And we don't need to, I wouldn't push to do anything to the bill. But here, I think it would make sense to amend our comment because our comments expressly mentions the change that has now been omitted. And so it would be confusion in the record for us to talk about something that wasn't in the bill. So the bottom line is that if the commission is okay with this, we will eventually bring back a bundle of comment revisions for you to consider to conform to these kinds of variations that I just described.
Any concerns with coming back with a comment? Hearing none, seeing none.
Okay, so the other thing in the memo is just information that there are 3 measures pending that would assign us new work. The first we talked about at a prior meeting because it was actually introduced last year. It's a 2-year measure now. Assembly Concurrent Resolution 95, Cunningham and Wicks would have us study antitrust law. That's a gross simplification of what they're asking us to do, but that's the thumbnail version. SCR 92 is new this year. This is from Senator Leiva's office, and I spoke to her staff, and the idea is that if the Equal Rights Amendment achieves the state approvals necessary for ratification, which I guess there's a legal question about that because the ERA itself had some language setting a deadline for state approval, and the arguments are going to be that that's not binding. But if the ERA reaches that level of state approval, California wants to be sure that there aren't any impediments in California law to full effectuation of the impact of that constitutional amendment. So that's what that study would be. We would be looking at California law in toto to try to find sex-based distinctions that would be problematic with respect to the ERA. And the language there is a little odd because it tells us that we're also supposed to look at regs and cases. And we obviously can't do anything to affect case law, not as case law. But what I construe that to mean is that we should look at all the sources of law for problems that could then be addressed through statutory reform. So quite broad. And then the last is AB2503 Garcia. This came out of the Assembly Committee on Judiciary. It's fairly common in our history for somebody to bring a bill to one of the committees and the committee to think that it's not quite ready, that a harder look should be given. and to convert that bill into a study bill that assigns us the task of taking the harder look. So that's what this is. This was a bill that was technical in its effect. Its aim was to standardize the terminology relating to lessor lessees in residential tenancies. And the committee was not sure that the bill had everything exactly right, and they maybe didn't go far enough, I don't know, but they had concerns about the sufficiency of what the bill was doing. So they asked me about assigning it to us, and it's their call. But I did ask, I suggested that they not ask for a one-year turnaround because we're just so jammed right now. And if these other studies come, it's going to be really hard to squeeze this one. So they gave us a 2-year turnaround, and I think that makes it more absorbable. So that's what's in the wings. I don't have anything else in connection with that memo to present.
Okay, any other questions or comments?
Actually, I have a
Yeah.
question about the antitrust. Do we have more explanation about what that's intended to be?
Yeah, I'm afraid I don't have the language in front of me, but the resolution has quite a bit of detail. And I'd say the gist of it is that in particular, they want us to look at the Cartwright Act, which is the state statute, against the background of federal antitrust law with an emphasis on tech monopolies. So not a big deal.
That's why I asked.
Yeah, I think it's about large Facebook, Google, etc. And the extent to which the existing law is insufficient to handle perceived problems in that area and what changes would make it capable of doing that.
Okay. Any other questions or comments on this topic? Seeing none?
My only comment would be, all three topics sound amazing, and I'm actually excited about that. And I think perhaps in the future, thinking about how the commission can form subcommittees to deal with the separate topics to help the staff or come up with, ideas.
Yeah, I would have to look into that a little bit. I mean,
If that's allowed, right?
in the abstract, the Open Meeting Act only prohibits action by a quorum of the commission outside of a noticed meeting, and our quorum is 5. So a subcommittee of, well, all 4 of you could get together. All 4 of you could get together and do anything you want related to commission business, and I don't think that would be a violation of the Open Meeting Act, except that I know there has been some legislative attention to subcommittees, and I would have to do some research to make sure that my understanding is correct. The commission hasn't generally not used subcommittees, not for decades and decades, but certainly those are both going to be both of the resolution-based topics, the ERA and the antitrust, are going to be ones where there's going to be a heavy lift. And we're definitely going to want to include outside experts to educate us. And it may make sense to do public meetings throughout the state if we're not able to do them electronically. And so it might make sense for there to be a Southern California subcommittee and a Northern California subcommittee. I just want to make sure there aren't any hard statutory rules against doing that kind of thing. But I like the idea.
I'll volunteer for the ERA one.
Okay. Yeah, I thought that was a delightful topic. It will surprise me if there's much wrong with California law with respect to these issues, because California is California. But
Maybe out of date terms or.
yeah,
things like
no
that.
harm in looking.
Okay.
Anything else on that?
Hearing none, seeing none.
Okay.
Emergency related reforms. Kristen.
Good afternoon, commissioners. So today before you, you have memorandum 2022-27. The big thing for the commission to consider is sort of the proposed structure and content, like big picture content of the informational report. So just to sort of reiterate and situate everyone, the commission previously decided that they would prepare an informational report on the issue of emergency law, focused generally on the balance of legislative and executive power in an emergency. So one of the things that the beginning of the memo talks about is, well, what are we looking at here? There are some great summary resources out there that I drew upon when I was pulling together information from different states. Of course, some of those came up during the pandemic, some of those preceded the pandemic. There are a lot of moving pieces in this area of law generally. So the things that I cited in the memo, I went and double checked to make sure everything was up to date. But I will note that things are still moving. Some of the resources that I used may not have included everything that's out there. The world of possibilities is large. So the beginning of the memo also discusses how we might perform the policy analysis for the different approaches that we're seeing. It lays out a set of policy objectives that, when looking at each approach, we will take a look at the policy objectives and see how we think that approach fares with respect to those different policy objectives. So the policy objectives are listed out on pages 2 and 3 of the memo. Those include certainty. So particularly, I think in an emergency, you don't want there to be questions about who has authority to do what at what time, what the necessary steps are. Feasibility. And of course, this is a big one, and this is a challenging one in the area of emergency law, because right now we are still dealing with the aftermath of a big public health emergency, but emergencies can include a wide variety of things. One of the things that I had to think about a lot was communication and infrastructure disruption. Thinking about public meetings and whether or not we're going to have access to internet or just regular communications. To the extent we're requiring things in emergency law that aren't going to be feasible in an emergency, that's not going to make a lot of sense. Information input and output. Now, this is just kind of a general good governance policy. You want the public to understand what you're doing. You want there to be an opportunity for the decision maker to get input and take that input into account. Of course, some of those policies and procedures that you use to put out information and gather information in an emergency are going to look different, but it is still important for transparency and accountability to have that. Oversight. So in some cases, you might have problematic abuse or inaction. We need mechanisms to address that. That's helpful. And then speed and nimbleness. In emergency law, things might be changing quickly. You need to react fast. You need to, take action right away. So to the extent that the law slows things down, that might be a concern in certain situations. The memo notes those policy objectives are not entirely independent. There are definitely some relationships between information input output, for instance, and oversight. Of course, you need good information to do good oversight. And then in some cases, the policy objectives may be a bit at odds with one another, where you have an opportunity to comment, take into account comment, that decision-making process will take longer. So those are the things that you kind of see throughout when in the second part of the memo, we applied these policy objectives to different approaches to establishing an emergency under the law. And so you often see that there's some of those trade-offs and some of those relationships there. So one of the questions for the commission today is, are there other policy objectives that the staff should be looking at in analyzing emergency law?
There's a pretty good list myself. I mean,
Okay.
there may be other stuff that comes up as we sort of get into some of the details of the policies themselves.
Sure.
Any commission members identify policies that they think we ought to add? Hearing none at the
Okay.
moment.
Well, yeah, so if there are things that come up,
Yeah.
definitely let us know. We can fill those in back, but we wanted to kind of make sure that the set that we had initially was a good place
Good
to
start.
start.
Good start, yeah.
So moving on from there, the memo notes that there are 3 key procedural steps in emergency law. And generally, over the course of the next few memos, I anticipate we'll be moving through those essentially chronologically. So this memo just presents for the establishment of an emergency, what are the different policy approaches we've seen here? Let's apply the policy objectives and kind of talk through what the policy analysis might look like. The exact structure that will show up in the informational report will not necessarily be what you see in the memo, but in terms of content, this gives an idea of what to expect. Going forward, I think that the second step is going to be sort of the exercise of powers during an emergency, but also what sort of legal, are there laws out there that just activate during an emergency? So it's not just powers and what someone could actually do during an emergency, but certain laws may be out there just sitting and waiting for an emergency to be established, and then all of a sudden they set new rules. And the last step would be termination of the emergency. There's a big variety in the states about how long an emergency can last, who can extend that, and we'll be discussing that in future materials. So unless there are any questions about sort of those general content pieces.
I have one
Okay.
question, which may have been answered before I joined the commission, which is, it would seem there's another policy objective,
Okay.
which is limiting declarations of emergency to emergencies. Has there been discussion about the definition of emergency as a policy objective?
So not that I recall, there hasn't been a specific discussion of the definition of emergency, and that's not something that we got into here. I will say one of the challenges generally in kind of looking at different approaches is that you see that some states have laws specifically for specific types of emergencies, and there may be kind of carve-offs for certain types of emergencies. You might have a declaration of a public health emergency specifically, and that might have a different set of rules than a state of war emergency versus a regular emergency. In terms of kind of limiting it to an emergency situation, I mean, I think that relates to abuse, but I think you might be talking about something a little bit differently, which is whether or not we crafted the scope of what emergency law covers.
Yeah. Sort of the kind of the standard that governs commencement. So it's more an element of the emergency regime rather than the policy goal. I think the policy goal would probably be something we haven't really talked about, which is restraint or not avoiding overuse, that kind of thing, or clarity. I mean, we talked about clarity. It's like you want to know what the standard is. You don't want to wind up in court immediately when you act. But we could easily, in a future memo, include a discussion of the standard for establishment of a state of emergency and run it through the same sort of policy rubric.
Yeah, I don't have a specific phrase in mind. It
Yeah.
just struck me that was the only thing that I saw missing from the rubric, unless we consider it to be part of the certainty.
Yeah.
Element that's already there.
Yeah, I mean, it's difficult because you want the law to allow quick action in unforeseen circumstances, but you don't want it to cover things that it shouldn't cover. So it would be a hard problem to solve. I think California has solved for expeditiousness, right? The standard is quite relaxed and gives the governor a lot of discretion.
And it also sort of overlaps with oversight, because you could imagine that if an emergency is declared, there are certain powers that the governor or legislature or some administrative agency has that don't exist in the absence of that, that someone might want to use by declaring an emergency just to invoke those powers so that they can do something they wouldn't otherwise be able to do.
Yeah.
But I think one thing you said jostled my mind, which is another way of thinking about the restraint on the standard, is that you might be liberal up front to allow the governor to act, but then require some kind of ratification or check after the fact, so that if the governor acts unreasonably, some other actor can restrain it. I mean, that's what came to me when you said oversight.
Right. And I'm thinking back to, my days with, when we had a Democratic legislature and a Republican governor, and might want to try to create a situation where it changed the balance of power in over some kinds of actions and activities.
Yeah, and I will say, generally, emergency law shifts the balance of power dramatically in favor of the executive.
Right.
So that is something where I think some of the mechanisms that we're talking about how to, for the legislature to sort of reclaim some of that power, or how the legislatures have for themselves set limits on what the executive can do. I think we could definitely look into some of the definitional issues. I will say generally, I mean, some of the more specific, public health emergency definitions might be harder to compare with what we have. And I do understand that there have been a lot of controversies over the exact definition in some cases as they were working through those, because it is a challenge to craft something that's flexible enough without being too.
And I would not suggest wading into definitions, because there's a lot of work here already, and attempting to define it will largely fail after a tremendous amount of work. I'm just flagging that it's an issue that seems to float among some of the policy objectives already here.
We'll give some thought to maybe how to tease that out for separate attention.
Yeah. Thank you.
I had a comment also, or a question really. I'm not necessarily sure. I don't believe it's part more so of the policy. It's more, I think, of the content. One of the things I was a little surprised in looking at just the overview is the no discussion of funding allocations. Is this study going to be looking at that as well?
So to the extent that there are different rules on funding during the course of an emergency, those would potentially come up in sort of the next phase of materials. There are, rules for, and I have not looked at these closely yet, so I don't have a lot of information, but there are mechanisms set up for how money can be spent during an emergency after the emergency has been declared. And those kinds of things would be something we would be looking at in kind of the next step of this.
Yeah, we're kind of moving chronologically through the emergency. So you have the initiating declaration that creates the legal condition that then springs into effect powers, spending authority, et cetera. And then you have actions that can be taken to limit or terminate that special legal condition.
Understood. Great. That's very helpful to know just the scope. The other issue I wanted just to kind of flag, it seems like the conversation in the memo was really about who should be able to do this rather than who must, when speaking about the executive or the legislature or other different. So I wondered if we could maybe tease that out, if there are particular requirements that require action, right? Someone could make a decision and choose to sit on, is there a responsibility to act? Are we going to be addressing those issues as well?
I think we will. It's going to be probably the bulk of that will fall into the discussion of the powers that exist during a state of emergency. The commencement, it's hard to make the declaration of an emergency mandatory. There's just so much discretion built in at that front end.
I will say, I think the only way that this memo maybe touches on that issue a little bit is, there are some states that allow a legislature to step in and declare an emergency. And that would be presumably if the governor has refused to act. So they're, having someone else who can take action in a situation where it feels like the executive is not taking the action that people think needs to be made, that comes up a little bit in this commencement piece, but not necessarily. A lot of emergency law really does rely on executive action. So I think it's a tricky issue.
It's the balance of power. One can imagine the converse as well, where someone declares an emergency because it creates a situation that is to their advantage for some purpose, and the other the legislative branch, if in this case, thinks that's stupid, why did we do that? We need to shut that down because that's nuts. You know, you could imagine the sort of, that's where the sort of balance of power and the pluses and minuses and the trade-offs become a big deal.
Yeah, no, there is definitely a push-pull, and I think in some cases, you know, it became very politicized during the COVID-19 pandemic, where you kind of saw those battles for power in some cases, because, you know, the legislature may want to hold more of that power for itself and doesn't want the executive to be able to make the decisions that emergency law typically allows it to make.
Right.
So.
Okay.
So
What else?
thank you for all those comments. I will just say, starting on page 5 of the memo, the remainder of the memo is really kind of an application of what the policy analysis will look like, thinking about the initiation of the emergency. Typically here, we've defaulted to California terminology, and terminology might differ from place to place, but in California, it's typically we're proclaiming a state of emergency. And so, you know, the memo goes through who can proclaim an emergency. Well, in California, that's the governor. In other states, like I said, they may allow either the governor or the legislature to do that. And I think, you know, one of the benefits of that would be if the legislature feels like the governor hasn't acted and should, then they would do that. Now, a potential problem with that is if you've got a governor dragging their feet on this, declaring an emergency and giving them more power is not necessarily going to achieve, I think, what you might want to do. But that is, you know, a policy difference that is seen out there. It does allow for the legislature to have more oversight. I'm not going to walk through all of these, but I will just sort of highlight some of the questions and walk through them briefly. So the next one is how a state of emergency is proclaimed. Do we allow it to be, in California, it's got to be in writing. In other places, they actually recognize that maybe that formality is going to be difficult to comply with. So you allow an initial verbal proclamation with a follow-up written one. Whether or not there's required contents that must be in the proclamation or not. California generally does not say much in its statute on what should be in there, although there are some provisions that sort of assume that there will be like geographic boundaries on the area that the emergency is in. How is the proclamation distributed and noticed? And can or must the governor call a special session of the legislature? One of the interesting things that I'll note about this question in particular is it starts touching on areas of general law in ways that are complicated and the staff could not fully research. In many places, the legislature may have the power to call itself back into session. Legislatures do not necessarily operate on the same schedule that California does. We have a well-resourced full-time legislature. So some of the concerns about whether or not the legislature needs to be called back into special session may be more acute in different places. In California, the law does not say anything specific with respect to a special session during an emergency, although the governor has pretty broad general powers to call a special session. But in some places, the governor is expressly authorized to call a special session in an emergency or is obligated to. And in some places, even just the emergency proclamation itself will automatically trigger a special session. So, like I said, I mean, that material is all presented and the policy analysis is out there. If there are any comments, questions, or concerns about any of that, I'm happy to address those, but I don't know that I need to walk through it in more detail unless the commissioner has any questions.
Questions or comments?
I mean, the general approach is that she's going to be creating sort of a walking tour of emergency statute policy. Like, what are all the kinds of major operational issues that could come up? And for each one, how does that bear on these various policy ideals? And then once we're done with that, and we'll do it in these public meetings, so if it triggers any kind of discussion or input about gaps or changes, once we're done with that, we'll compile it all into this informational report that we're building, maybe with a little bit of compaction.
I had a question. So thank you for that summary, Christian. It's always great to see your fabulous work. I had a question. I know that this is just, it's curiosity really, But it would be helpful, I think, as we go through it, to see some of the examples as to why there are exceptions. So for example, the memo discusses how the only 2 states are Delaware and Arkansas that allow verbal forms of approval, right? It doesn't have to be in writing. I would be curious as to what type of emergency that has been used, because it seems that in California, obviously, as you've gone in detail, is we have this extraordinary power given to the executive with a lot of discretion. But I was curious with the idea that it was a lot more simplified in these 2 states. And my question is to why, if there's
Yeah,
if there
so
was something.
I will note 2 things. One, this memo is not intended to be exhaustive. It may be that
Yes.
there are other states out there that allow that. I really did just try to find some example that seemed to, really speak to that question. In both of those states, the initial verbal proclamation is intended to be sort of short term. And it is kind of recognizing that the formalities of an official written proclamation cannot be complied with initially. Now, I don't know the specific, concrete situation in which that might have occurred, but the idea, I think, in both of those statutes is once you can comply with the formalities, you will go and do that. It's just that in some cases you may need to take emergency action before you can, comply with that formality. And now that certainly seems to be an extreme case, because a written proclamation seems like a, relatively low bar, but it would offer you a little bit more flexibility in some extreme emergency circumstances, I think.
An earthquake or something like that, I suppose.
Yeah, I mean, I can try to take a look and see if there are any, if I can get any more clarity or if that's ever been used. I mean, I'm not sure that there would necessarily be good records of the verbal proclamations, but I can look into it.
Yeah, I mean, if we could provide the examples as sort of historical context, we will, but, for the purposes of the analysis, I think it's enough to know that there are these different approaches that can be taken, and then we can sort of theorize about why they might have been why you might choose to do it that way and what the pros and cons are.
Yes, that makes sense. And I don't necessarily, I'm not requesting that additional research be done on this particular issue. It's more of an example of when discussing this, I find it helpful to have the context a little bit more of why these are exceptions. Like if there's a summary of what, but that's all, but thank you.
I wonder if we should check our audience.
I was going to say the same thing. Yeah, should we?
Megan, could you take a look at the attendees?
Anyone from the audience who would like to comment or be heard about on the
please
emergency?
Raise your hand if you do.
Yeah.
And I think that the list auto sorts so that raised hands are at the top. What a world.
I will just make a brief note while we wait, in case anyone does want to raise their hand. The memo also includes a little bit of material about the draft Public Health Emergency Authorities Act, which is being crafted by a committee of the Uniform Law Commission.
Chaired by Diane Boyer-Vine.
Yes, who has graciously answered several of my questions. It is now at the ULC Style Committee, and it's intended to go before the full body of the ULC at its annual meeting in July. It will be a model act, not a uniform act, I believe is the intention. And it will apply specifically, as the name indicates, in public health emergencies. So it would supplement sort of general law on other types of emergencies and really apply in this context, thinking about what we're dealing with COVID, focused on that area. Generally, it requires more substantive findings, more reporting, more information to be communicated between the governor and the legislature. And there's also just a bit of information about the relationship between the state, local governments, and penalties related to violations of orders.
Okay. I don't see any hands up, or there is anybody indicated?
No. So
Alrighty.
you can drop that list.
Okay, any other questions or comments by members on the emergency procedures? Seeing none, hearing none.
I will
Thank
make
you. Oh, yeah.
one final note. The last thing in the memo is just about outreach. And so there's a list of groups that we actually reached out to all of them. I think there's one or two that we have had some contact information problems with. And then we have notified certain committees and leadership in the legislature as directed by the resolution.
Okay,
If there are any other stakeholders we should reach out to, just feel free to let me know.
Great. Thank you.
Thank you.
Okay, and our last agenda item is the Fish and Game Law.
Since we have people here for it, I wonder about taking the memos out of order and dealing with the organizational issue first, because I think that's requires discussion and the other one does not.
Okay,
Is that all right?
that's fine.
Okay. We good?
Yes.
All right, so that's memo 2230 and 5 supplements. The 5th supplement was distributed this morning, and as I explained when I sent it out to commissioners, that was given, the content there from the Department of Fish and Wildlife was given to us at the end of April, and I should have distributed it at that time. The failure to do it at that time was my mistake. I just missed the content in the email that told me to do that. So as soon as I was notified this morning of that, I distributed it to our mailing list, and I've given you hard copies too. And I apologize to the Department of Fish and Wildlife. We have not had as much time as we perhaps should to consider the details of the analysis your staff did. And so whatever else happens today, it would be my suggestion that if the Department of Fish and Wildlife thinks that the delay prejudiced their position, that, like I said before, we're not in a great rush on this. We could leave the item open if everyone feels like it would be helpful to have more time to consider what they've written. So the background on the materials. At the prior meeting, we considered comment on the proposed reorganization and creation of the Fish and Game Code. Let me just say operationally today, if you want to be seen and heard, you'll need to go forward because you're out of frame, and you don't have to, as long as you know, it's fine if you want to speak and be picked up by the microphone, but just to let you know, you're welcome to move up if you want to. So at the prior meeting, we discussed the comment on the tentative recommendation, which would have created a new Fish and Wildlife Code. And specifically on the question of whether to make the organizational changes that were in that tentative recommendation. We had a letter at that time from, I think we had one from California Waterfowl, as well as one from the Department of Fish and Wildlife from their director, expressing concern about going ahead with that. And at the time, I argued for pragmatism, and it was my recommendation that rather than push forward with the full tentative recommendation, which I think would have been a very hard process in the legislature and in the governor's office, that we instead conduct an experiment where we look at the possibility of doing some organizational improvement in place in the existing code on a narrower footprint of a more modest intensity, and see what the reaction was to that. My sense being that if a very light touch with very minimal burdens associated with it was still more than the department could support, then we would know where we stood. So the commission's direction to me was to prepare such a narrower proposed reorganization of Division 2. And in terms of its intensity, the decision was made to limit it to shuffling around the placement of chapters without making any adjustments to the interior components of those chapters. So I did that, and that is what is attached to the main memorandum. I think in the main memorandum, I also included a section where I pointed out a couple of further steps that could be taken if the commission decided it wanted to be a little more ambitious. One of those was fairly modest. It had to do with sort of grouping and more coherently consolidating provisions at the end of the code that relate to interjurisdictional cooperation. And the other was more ambitious, and it had to do with combining much of the content of divisions 2 and 3, while moving chapters out of both divisions and then consolidating 2 and 3. But those were possibilities. They weren't the main proposal. And I will say, with respect to the main proposal, one of the advantages of the very light touch that we took was that really the organization consists entirely of moving, like, I think 4 chapters, 5 maybe. And so most of those chapters that are already in Division 2 would now be in a Division 2.5, I think, and could stay in their current locations, which means the sections would not be renumbered. So all of the heartburn and cost associated with dealing with code renumbering would not be present, at least with respect to those. It would be present for the few chapters that we were proposing to pull out and relocate. And also, if you don't change section numbers, then you don't have to amend regulations that reference those section numbers, either in the body of the regulation or in the sort of historical notes that OAL requires that are included actually within the 4 corners of the reg. So that's the proposal that was in the main memo. Now, the commission had also asked me to do a couple of other things. And I did those other things, I believe, in the first supplement, which was talk in more general and abstract terms about the advantages and disadvantages of statutory cleanup work, recodification. That memo does that. And I'm happy to answer any questions about it, but I'm not going to walk through it. It's pretty general. The other thing was to discuss the idea of, like, how would you schedule further work in this vein if we were to do it? What would that look like? What would be the longer term plan? And I admit to being reluctant to spend a lot of time on that. I understand the value of it, but at the last meeting, you know, and still, I don't really want to put a lot of effort into figuring out a long-term plan if there's a realistic prospect that the work is going to be tabled. But I did do some discussion of possible next steps, just not a lot. There's actually a fair amount of work involved in, like, looking and sort of dissecting a chunk of disordered law and figuring out what would you do with it. And so, you know, forgive me for not fully complying with the request, but I still think that it would be more efficient to decide whether we're going to do that at all before putting the effort into figuring out how. So then we got 2 other supplements, the second and the third, which are letters. The first from Mr. Hennelly, I believe, from California Waterfowl, who was the person who wrote last month as well, sort of re-upping his position, but now in the context of this narrower reorganization. So it's not a letter written in response to the proposed code, whole entire code revision. It's a response to this more modest reorganization. And he basically takes the same position, expressing concern about the work. I think in general, the fear that it would be counterproductive. Make the law harder to use. And I'm not going to speak for them. The third supplement was an omnibus letter that we got that was very similar to Mr. Hennelly's letter, but now on behalf of several groups, including, sadly, That was, I forget which city it was, Santa Barbara Zoo. I was sad to see that the zoo had lined up in opposition to this. So we had 10 or so entities writing to share their concerns about any further reorganization of the Fish and Game Code. And then yesterday, I got another letter from another 10 or so entities expressing similar concerns in response to any further organization. And then, as I said, I was alerted this morning to my error in not having forwarded the letter or the email from Wendy Bogdan, in which she shared some of their concerns about the reorganization, and that included an attachment, which is included. And I'm sorry about the tiny text. I don't know how to PDF a document that has inline comments without producing tiny text. But they identified a number of more specific concerns about some of the choices that were made in preparing the proposed legislation that was attached to the main memo. I think this work that we're considering presents us with a number of double binds. It's, for example, one of the things that I think is a vulnerability of the approach that we've taken is that one could argue that by choosing to leave the chapters intact, we are preserving too much disorder. We're not doing enough. And therefore, because we're not doing enough, it's not worth the candle. But on the other side of the coin, if we were to bite off more, we'd be opening ourselves to the criticism that we're doing too much, and it's more disruptive and the costs become unbearable. And I think a concrete example of that, in the analysis that was attached to Ms. Bogdan's email, there are a number of points where they talk about this chapter that's currently in Division 2 that we propose moving into what we would preserve as Division 2 and not include in the new Division 3. It's this chapter on department managed lands. And we said, okay, department managed lands, let's move that out of what would be new Division 2.5. Let's put it up with the rest of the stuff in Division 2. It's department powers. That was the thinking. The commentary at a number of points in the document we were provided says that that's erroneous because the heading of that chapter, department managed lands, has very little to do with its content. Well, that's the existing chapter name. That's the existing title of the chapter. So it's not like we're creating an inappropriate chapter title. There already is one. And so to my mind, that sort of demonstrates the disorder in the code that this existing chapter, according to the commentary we just got, the contents don't match the label. So if we're critiqued for leaving that problem in place because we're not disturbing the contents of chapters, then we're sort of, like I said, we're in a double bind. We didn't dip down that low and achieve that degree of intensity. And so now the work can be criticized for being imperfect because it doesn't fix problems below the chapter heading level. But if we had proposed to fix things at the section level, the draft you got wouldn't have been 100 pages. It would have been 600 pages. And the fodder for criticism of the choices that we had made would be multiplied manyfold. So it's very difficult to find a Goldilocks spot where what we're doing is everyone agrees is the right level. That's all I'm going to say sort of about the content, the substantive content, unless I'm asked questions. I think there's something to say about pragmatism, where I'm going to sort of reiterate the point I made at the last meeting as viewed through the lens of the new material, which is, you know, the goal was to create a test case, to just sort of dip our toes into the water and see whether there would be opposition, no matter how modest our work was. And I don't, you know, this was pretty modest. We could have gone smaller. We could have chosen to have less breadth to it. But even that, we wrote 4 chapters intact. It's hard to imagine a less disruptive organizational change. Despite that, we're still getting this exact arguments that we got against the proposed code as a whole. And we're getting more of them. So we're getting not just the input from the department, but also from the stakeholder groups that were part of the strategic vision body that was the originator of this whole project. They're being copied to our assembly member and our senator and the governor's office. I understand the department has requested meetings with our assembly member and our senator. So to my mind, merit aside, it's clear that there's going to be pretty effective opposition to anything that we do organizationally. And I have always told people when I talk about this work that we do, that we're not an academic body. We don't just write reports. We try to improve the law for the people of California. And you don't improve the law by proposing unenactable proposals. And so that's my take on it, is that I am reluctant to think about trying to work this bill, even if we could find an author, which I'm not sure we could, and getting 30, 40 opposition letters and sort of criticism on every decision that we make in terms of how the thing is framed. And also the other point I think that's important to recognize, this was in Ms. Bogdan's email, so I didn't discuss it earlier. There's also a statement that they won't be able to expend any more resources for the organizational work that if we work on it. So we will be moving to the legislature with a product that has not been vetted. I would take the input they have given us, and I would do my best to take that into account and improve the product. But the impression that I have, and I can be corrected if I'm wrong, is that they would not expend further resources to comment on or help perfect the product beyond that. So I think we'd have a bill that potentially has vulnerabilities in it that we haven't detected, that would be opposed on the basis of broad issues and some laundry list of those vulnerabilities, opposed by many, many stakeholder groups. And as I said at the last meeting, because this is legislation, the last word is the governor. And we typically, as sort of a posture of neutrality, we have always historically stayed out of the governor's process. We mostly stay out of the legislative process, except to offer explanatory background. So we don't really have a place at the table when the governor decides whether to sign or veto a bill. The resources agency does. And so my sense is any organizational work on the Fish and Game Code is likely to be fruitless. And my preference would be not to spend further time on unproductive work, much as I hate to say that.
I have a question. Have we experienced anything like this before where it just seemed like the task is insurmountable, or
Well, I guess there's
impediments are insurmountable?
There's a couple of ways to answer that question. We have run into opposition with recodifications. Commissioner Hebner was maybe present when we did the David Sterling Common Interest Development Act.
What was just percolating in my head.
Yeah.
And
And
use developments for all those years.
yep, we did a proposed reorganization of the David Sterling Act. And we went into the legislature knowing that there was opposition from industry lawyers. And we got through the Assembly, we got to the Senate, and they dropped a letter on us in the Senate Judiciary Committee at the last minute. And it was more than we could handle, that we were told to, by the legislature, to drop the proposal. So we came back and we ran it a second time. We went through the process again with a much more conservative drafting approach, buttoning everything down, trying to bulletproof it as much as possible. And that time we got it enacted. And the industry lawyers wound up giving me an award for that statement. The other example was when we did the years-long study on mediation confidentiality. You missed that. You were very fortunate.
I saw it, I've watched it from a great distance.
Yeah, it was a debacle. The problem that we had was that the question was, there's a general rule that mediation communications are confidential and privileged. You can't introduce them into evidence and legislation, can't even talk about it. The question arose whether that there should be an exception to that policy for evidence that you yourself want to introduce to prove your own attorney's malpractice in the course of the mediation. The industry was absolutely insistent that the confidentiality had to be absolute. Because to crack open the confidentiality would be to destroy candor, et cetera. But the commission was really convinced by the argument that, every wrong should have a remedy, and you should not insulate attorneys from malpractice liability during the course of the mediation by making any evidence of that from the mediation itself inadmissible. So that was the commission's recommendation. We went through years of very contentious meetings. And the commission was divided. That's the first time I've seen in like 30 years that the commission's vote on a final recommendation was divided, and usually unanimous. And we failed. We took it to the legislature, and I couldn't get an author, and I actually got chewed out for the temerity of bringing this pointless proposal before the legislature. And I'm not eager to go through that again. So yeah, we have had situations where we set pragmatism aside, and there were discussions in our meeting about pragmatism, and there were commissioners saying, no pragmatism. This is the right thing to do. And it was their call, but we hit a wall, and I don't want to do it again.
Mr. Chair, I know we have some guests that would
Yes.
perhaps like to speak. I would ask that we hear from them.
Okay.
Yeah, I agree.
And then we can debate and discuss. Would that be okay?
Yeah, no, that's fine.